the video no longer exists. This is one of the pitfalls of representing yourself. I try and tell people in every arraignment, I tell people I give them essentially the Ferrata warning. Like, there's going to be some difficulty getting information into the record of the court or understanding the procedures of the court when you represent yourself. And it's not.
Viewers,
Right out of the gate, this is the first major legal fork in the road. In criminal procedure, discovery isn't automatic just because you ask nicely in court. You have to formally request it, usually in writing. If you don't trigger the process correctly, the clock keeps ticking. And here's the kicker: retention policies don't pause because you're confused. Question for you: should courts be more forgiving with self-represented defendants, or is procedure no matter what?
buckle in, because today's hearing is a masterclass in how fast a simple traffic case can spiral when you try to outsmart the system without actually knowing the rules. We've got Mr. Okafor a defendant convinced the key to clearing his stop sign ticket was hidden on a police video he never properly requested. And we've got a judge who is absolutely not buying the "I asked verbally" defense, especially after hearing he ignored the officer's clear instructions to file an open records request. His attorney jumps in late, the state pushes back hard, and then the judge drops a reality check that freezes the whole courtroom. And trust me, it only gets sharper from here.
Wena Chukwuma Okafor. Okay, this case was closed. The motion was for new trial with Attorney Toombs. Mr. Toombs, you want a motion for new trial?
Yes, Your Honor.
Okay. What's going on?
In this particular case, Your Honor, Mr. Okafor, he came to court and there was a video. The police officer had stated to him that there was a video and no one never produced the video. He says all he wanted to see was the video because he stopped at the stop sign. And he asked him for a new trial and asked when we would like to have some discovery where we can see this video. So all he wanted to do was see the video because the officer said he had stopped and but he didn't stop for 3 seconds. And she said she had it on video. This is all he wanted to see was the video because he stopped.
Okay, the request, so the issue, Mr. Toombs, is did he make a request for the discovery?
And this is where the technicality becomes fatal. The state just confirmed the video expired under standard retention timelines. That means even if it once existed, legally it's gone. No bad faith, no conspiracy, just bureaucracy doing what bureaucracy does. When evidence disappears because no one preserved it properly, courts usually look at who dropped the ball. In this case, it's not looking good for Mr. Okafor.
I didn't represent him at trial, Your Honor. He represented himself. But we asked in the interest of justice that he be given a new trial.
In the state?
Your Honor, at this time, we ask that you deny defense motion for new trial. Number one, the issue is now moot. After speaking with Officer Richards, that video has not expired due to the retention timeline, so it's no longer available. She can't get it, we can't get it. And number two, Your Honor, like you touched on earlier, the defendant was told by Officer Richards to file an open records so that he can get a copy of that video. The defendant failed to comply, failed to follow Officer Richards' guidance, and so for those two reasons, we do ask that you deny defense's motion.
Well, Your Honor, he asked for the video over and over. He has a real
okay. Asking for it and putting it in writing is two different things, Mr. Toombs. And we know organizations like writing. Did he put anything in writing requesting this video?
Not that I'm aware of. He didn't know to do that, but he asked for it at trial. He requested it. He mentioned it. And no one never, listened to him or mentioned anything about the video that the officer said she had. She had him on video. So it's all he wanted to see was the video. So we asked that the court set aside the judgment and reopen this case.
This is the courtroom reality check. Verbal requests feel satisfying, but courts run on documentation. Think of it like certified mail versus telling someone in a hallway. One creates a record, the other creates a memory, and memories don't win appeals. If you're representing yourself, this is the trap: confidence without compliance. Would you have known to file a written open records request?
Okay, well, with the representation from Ms. Hagler, the video no longer exists, so there's no grounds for the court to overturn what's been done. Mr. Okafor didn't pursue the discovery. He didn't pursue it from the solicitor's office or the police officer, even though he was given directions to file an open records request. And then the video no longer exists. This is one of the pitfalls of representing yourself. I try and tell people in every arraignment, I tell people I give them essentially the Ferrata warning, like there's going to be some difficulty getting information into the record of the court or understanding the procedures of the court when you represent yourself. And it's not supposed to be impediments to it. You're supposed to freely be able to do it, but everybody knows that practically there are impediments to representing yourself. So at this point, the motion for new trial is denied. Mr. Okafor, also, you have SSD amounts pending. You have a balance of $491 due on your suspended sentence. So please continue to make those payments.
Your Honor, Mr. Okafor is not financially able. Is there something the court could maybe amend his sentence, and that it would be more suitable for his economic condition?
Mr. Toombs, the fact that you're standing in my courtroom representing him tells me that he got...
Someone explain this. Because we're watching the exact moment where the judge connects all the dots, and none of them land in Mr. Okafor's favor. This is why sovereign-style "I verbally requested it" logic never works. Courts don't run on vibes, they run on procedure. When the state says, "Did he put it in writing?" That's not being petty. That's the legal requirement. Discovery isn't a handshake agreement. And hearing the judge say the video expired because he never filed the request? That's the entire case collapsing in real time. And chat, did you catch how fast the conversation about the missing video turned into unpaid fines and inconsistent explanations about money, language ability, and representation? Every loose thread gets exposed when you try winging it in court. Here's the real question. Why do defendants think "I didn't know" beats written procedure?
Some economic situation going on, because that fine fancy suit done by itself. So, sir, I'm just saying, if he brought you into court as opposed to the indigent defense counsel, that belies the fact that he can't afford to pay his fines and fees.
Well, Judge, this is the first thing, this old suit. I had this suit waiting.
You make it look good, Mr. Toombs.
Yeah, I usually try to take care of my things.
But yeah, Mr. Okafor, you have private counsel, so that right there tells me that you're not indigent to the extent where I have to relieve you of your fines and fees, sir. Now, it's due. It was due April 26th of 2024. You're facing an arrest warrant if you don't pay it soon. So tell me, what is the impediment to you making your payments?
Did you understand? The jury said, no, what problem are you having making the payments?
Boom, motion denied. Legally, once the judge confirms no procedural error and no preserved evidence, there's almost no pathway to a new trial. Appellate courts look for mistakes in law, not regret about strategy. And notice how quickly the focus shifts from the video to unpaid fines. That pivot, that's momentum changing in real time.
Do you understand that? He doesn't understand that. He speaks very little English.
Mr. Okafor, why can't you make your payments?
Because I came to this, I stopped as I was supposed to stop on the sign. I want the court to see the video.
Okay, no, we're past that. There's no more video. So you owe $591. You've paid $100. You have $491 due, sir. And do you want to pay it? Not, you can pay it now. But you're facing an arrest warrant if you don't pay it soon.
Hello.
So you're telling me, Mr. Toombs, that Mr. Okafor decided he doesn't speak English very well, but he decided to represent himself, because I don't recall him having problems with English when he represented himself. And he is now telling you that he can't afford to pay his fines and fees, but he can afford to have you represent him in court on a motion for new trial.
Did you catch that collapse? The entire argument rested on a video that no longer exists because the correct form wasn't filed. This is why I didn't know almost never works in court. Judges assume adults are responsible for understanding the consequences of going pro se. Fair or harsh, you decide.
On a case where he represented himself, but now he can't speak English or understand me?
Well, no, I wasn't saying he can't speak English. I said he didn't understand what you were saying, the legal effect of what you were saying.
Okay, so the motion for new trial is denied. Mr. Okafor, you need to pay the $491 or else you're going to go to jail.
Could you give him some additional time, Judge?
I can. You know what, Ms. Powell, if you will give me a modification for Mr. Okafor, you can give him 2 weeks to pay the fines and fees in total so he can avoid an arrest warrant being issued. But we'll go ahead and get that to you. Just stay where you are and we'll get that signed and sent.
What about 30 days, Judge?
30 days, Mr. Toombs.
Well, 30 days, not that long.
Mr. Toombs, based on the fact that, you know, you've known me since I was a baby lawyer, I'm going to go ahead and give him 30 days.
Thank you. Thank you,
Yes,
Judge.
ma'am. All right. So Miss Powell's going to get that done. Once I sign it, I'll send it to the clerk's office and he can get a copy of it there.
Thank you. That's
all right. So just hang out in court until I tell you it's ready.
Okay. Thank you very much.
All right. Thank you.
Team.
And here's the surprising twist: leniency. After dismantling every argument, the judge still gives him 30 days. That's courtroom nuance. Firm on procedure, flexible on payment. It's a reminder that judges can balance accountability with discretion. Final thought: if he had hired counsel before trial instead of after losing, does this entire situation play out differently?
Here's the final breakdown. Mr. Okafor came in hoping to reopen his case because he believed a missing police video would clear him. But the system only works if you use it correctly. The officer told him exactly what to file, he didn't file it, and by the time he returned, the video was gone due to normal retention timelines. Without evidence, without written discovery, and without a legal foundation, the judge had no grounds to overturn the verdict. Then, the unpaid fines brought a second problem. His story about not affording payments didn't align with hiring private counsel, and judges absolutely noticed those inconsistencies. Still, in a rare moment of leniency, the judge extended his payment deadline by 30 days, preventing an arrest warrant, at least for now. This entire case is a reminder. Sovereign shortcuts, verbal requests, and courtroom improvisation always backfire. Follow procedure, get representation early, and never assume the court will fill in the gaps for you. If you're into breakdowns of real courtroom logic, legal fails, and the wild moments people think will actually work in front of a judge, hit that like button, drop a comment, and subscribe so you never miss the next meltdown. And turn on notifications. Trust me, you'll want to.